Help, my probate home is in foreclosure, but the lender won't talk to me. What do I do? We get into that next. Welcome back to the channel featuring the leading probate real estate team in all of California. I'm Brendan Mohr, Realtor, Masters Club Life member, and certified probate and trust specialist by the California Association of Realtors.
And I'm Bill Heyman. I'm a licensed California professional fiduciary, as well as I'm a licensed California real estate broker. And I'm also a registered and bonded legal document assistant specializing in probate and trust administration work.
Now go ahead and like and subscribe. And if you've got a house to sell, we can help you avoid the cost and headache of probate and trust administration. Those services come with the listing at a phenomenal discount with no upfront fees, saving families thousands in costs. We can even help with the petition to determine succession, the primary residence process. Our contact info is in the About section. Don't wait, reach out today. All right, so you have this house in probate and there's a mortgage, it's in foreclosure, but the lender won't talk to you. Now, once a home goes into foreclosure, it is imperative that the lines of communication be opened up. And there's a trustee who is basically on the mortgage itself. And they're the one that's going to be conducting the foreclosure with the lender. You've got to be able to talk to them. So the trustee and lender will not speak to anyone until that person has the proper authority. The deceased property owner is still the only one who has that authority.
Yep.
So the property owner passes away, they clearly can't speak.
Right.
How do the heirs, the loved ones, talk with that lender?
Well, this is something that we actually run into quite a bit with probate foreclosure homes. The problem is, as Brendan, as you said, is that obviously the deceased property owner, who's the only one who has the authority to talk to the lender and trustee, is passed on. They can't. So what you have to do is there's two options. The first option is you've got to open a probate, and you open the probate, and just because you open the probate does not give the person who opened the probate the authority right away. You have to get appointed by the court officially, or you have to get some sort of court order that states that this person shall communicate with the lender or trustee. So the way you do that is, again, you file and open the probate, and then you immediately file what's called an ex parte petition for special administrator. Ex parte, don't let that word bother you. It's just kind of an emergency way to get things done when you don't have time to wait, or you've got an emergency situation that just can't wait. So you file this ex parte petition for special administrator, and you want to ask the court in that petition for a few things. Number one, you want to ask them to order that you, Joe Smith, who's petitioning, order that the lender and trustee communicate with you openly about all facets of the loan. The second thing you want to get in that ex parte order is you want to get the court to order you to have the ability to list the property with a licensed real estate broker. And the third thing you want to do is you want to ask the court to give you the authority to accept offers and close escrow on the sale of the home. Now, I will tell you this, not a lot of courts will give you number three, but you still want to ask. I have had in a particular county where I asked for that and I got it, and we were able to actually sell the home off of that ex parte order. So that's what you want to do, and you can usually get those ex parte orders within a matter of a few days. So you can get them real quick. And once you've got that order, then you can go to the lender and trustee, and they have to openly communicate with you about everything about the loan, the situation. So it's just going to make your life easier.
I've seen you do this many times, and the look on the heirs' faces and the sound in their voices is just like this relief. I can't believe you just worked this magic here. Now, but what if opening probate is for some reason not possible at that time?
Yeah, sometimes it happens. I mean, sometimes there's a financial reason why the family can't open probate or some other reason. There's still a way to get the lender to communicate with you. Now, it doesn't always work, but I've had it work many, many times. Essentially what you do is you prepare some documents One of them is just called a third-party authorization form. That's just where one of the family members is giving permission to somebody to talk openly with the lender. The second one is there's a document that I've prepared many times called an affidavit of heirship. And it's basically just a 1 to 2 page document that states all the facts about the family. It says, Joan Smith passed away on such and such a date, attaches a copy of the death certificate. Here's the family members who are the legal heirs of the estate. And then basically the one heir or family member who is attesting to all that signs it, has it notarized. Then you send the third-party authorization form, the affidavit of heirship form, a copy of the death certificate to the lender and trustee. And oftentimes that will be enough for them to say, okay, we'll talk to so-and-so who signed the affidavit of heirship. Again, this doesn't always work, but I've had it work 60 to 70% of the time that we've tried it. So if you can't open probate, you can try that method, but really opening a probate and getting going with the ex parte petition that's the best way. It's the best way, yeah.
Now, clearly opening probate is the best way here. Now, what some of our audience is probably wondering, well, gosh, I'm not really familiar with mortgages. A lot of times we see that in probate.
Sure.
Whoever inherits a house, they've never owned a house in their life, so they're not too familiar with dealing with banks and all that. Whose responsibility is it? Say they go out and hire a service to help them with a probate, say an attorney. Can they have the attorney speak to the trustee for them?
They can try. I mean, technically, the attorney doesn't have the authority either. But sometimes, lenders and trustees, they're made up of human beings just like all the rest of us. Sometimes an attorney will scare them a little bit into opening up. But to the best of my knowledge, an attorney doesn't have any more authority to speak to the lender than one of the family members, unless they've got court authority.
And from my experience, not all attorneys actually have great skill in the real estate world.
Yeah.
Probate and real estate it's two different things. And there's real estate law. Well, that's not probate law. So who you hire really does matter in these situations, because I know that there's been ways for heirs of estates where they say, hey, you know what? Can you do this for me? What can they do there? They can probably have you as the administrator, correct?
Yeah, I mean, I am a licensed professional fiduciary in the state of California, and I'm actually the administrator for many estates for various reasons. Sometimes there'll be families who the heirs aren't fighting, but they may not necessarily trust each other completely. So they'll say, okay, well, let's have a third party that's disinterested, and so they'll hire a fiduciary like myself to be the administrator. And sometimes it's just easier. The family just says, you know what, it's just easier if you just be the administrator. And I do that all the time.
So what you're saying is, if they have a house to sell in probate, foreclosure or not, but let's just say foreclosure in this situation, they're not sure if they're going to be able to say the right things to the trustee, convey the right message to the trustee, the lender, to stop the foreclosure.
Sure.
They can hire you, nominate you to be the administrator,
Right.
save a ton of money in legal fees because you charge a lot less than an attorney, and the process goes a lot smoother, and they save the house from foreclosure.
Because if they do agree to have me act as the administrator, that just takes away an in-between step of trying to go back and forth with somebody. I can just go boom directly to the lender and trustee. Usually get it done much faster.
And of course, I was leading you on that question because I've seen you do it so many times.
Yeah.
So I knew what the answer would be. But please, if you have a situation like that, reach out to us. You do not want to delay when you're facing foreclosure, and especially in probate. Our info is in the About section of the channel. Reach out.